Good evening, friends. Let us understand what is conveyance, what is deemed conveyance, and what are the advantages of getting a conveyance, and then what are the procedure to be followed to obtain the deemed conveyance. Let us understand what is the meaning of conveyance. Conveyance means transferring of title, right title interest of the land and building in favor of a cooperative housing society. What happens in Maharashtra is usually the builders construct the flats, they sell the individual flats to the individual members, they enter into an agreement, they pay the stamp duty and register it, and thereafter the society is formed, and the very purpose of formation of the society is to get the ownership of the land and title of the building in its name. So once the land and building is transferred in the name of the society takes care of the regular maintenance, including repairs and major repairs, and collects the funds, takes care of various services to be given to the members. Now let us understand, once we understand that the conveyance is nothing but the transfer of right title interest of the land in favor of a cooperative society formed by the flat owners, which the land is right now standing in the name of builder and the landowners. Now what are the purpose of getting the conveyance? The first purpose is to become the legal owner of the land, is to make entries in the government record. And the third and most important is to have a free and marketable title. As on today, the flat which is owned by the members and the land is owned by the landowner, and the builder has got the development right, and the housing society maintains it. So though there is one land and the building, it is being having four different stakeholders. In order to have a free and marketable title, we need to have the conveyance. Now what are the major advantages of conveyance? The first and most important advantage is to get the ownership of the land transferred in the name of the society. That is the first advantage. So unless until you have the conveyance deed registered, you don't become the owner of the land. Second, whatever is the commercial benefit, whether it is related to the putting off of the hoarding, or whether it is increase in the FSI, all increase in the commercial benefit will go to the society. Third is, the societies which have got the conveyance naturally has a better appreciation value. At least 500 to 1000 rupees per square foot is available in addition to the regular rate. Then the societies, if they are going for a major redevelopment or they are going for repairs, they can go for raising the loan from the Mumbai District Central Cooperative Bank or the District Central Cooperative Bank or the Maharashtra State Cooperative Bank. So unless until you have a conveyance, you will not be able to get the loan. Third and most important is increase in the FSI. Today you are aware that in order to allow more and more construction in the urban area, the FSI is being increased by the local bodies. So in Mumbai is also not an exception. Earlier it was 1 FSI, thereafter it has, with the TDR it has become 2, then with the fungible FSI it has become 2.7, and with the latest development plan, the FSI is going to be minimum 3.5, and in the nearby station, metro station, it is 5, and nearby railway stations like Dadar and Andheri, it is going to be 8. So therefore, there is going to be additional FSI, and in order to load the additional FSI and to reconstruct the building, redevelop the building, you need to have the conveyance. So these are the major important points which need to be noted, and unless until you have a conveyance, you cannot enjoy all these benefits. Thank you. The conveyance is to be normally given by the developer. Under Section 10 of Maharashtra Ownership Flat Act, it is the duty and responsibility of the builder to convey the land and building in the favor of society within 4 months from the date of formation of the society. Now the question arises, if the developer or the landowner does not convey the land and building to the society within 4 months, what is to be done? And what are the methods to get the conveyance? So the first method is normally, you have to go to the builder, because he has the power of attorney given by the landowner to convey the land and building. Also, he has constructed the building, he has all the documents. So the first and foremost thing is, you have to go to the developer and approach him and ask for the conveyance. In case he does not give you the conveyance within the approved time, Then the next would be to go to the various courts. You can go to the consumer court, you can go to the city civil court, you can go to the magistrate court, even sometimes you can go to the high court depending on the situation, and then to the Supreme Court. So these are the various courts where you can knock the door and get. Third and most important is deemed conveyance. So what is the provision in the deemed conveyance? Under the deemed conveyance, what it says is the developer has to convey the land and building within 3 months from the date of formation of the, within 4 months from the developer has to convey the land and building within 4 months from the date of formation of society. In case the developer does not convey, it is deemed to have been conveyed. So this way there is a deemed provision, and once the deemed conveyance comes into picture, you can approach the appropriate authority, competent authority, and get the conveyance actually executed. So these are the 3 various ways. One, going to the builder who facilitates the conveyance, he brings the landowner and the builder himself comes and executes the conveyance. Second, where the court gives the order and the court appoints an authorized officer to execute the conveyance. And the third is where the deemed conveyance, where the after the statutory period, the district deputy registrar is considered to be a competent authority who takes the shoes, who comes into the shoes of the landowner and builder and gives the conveyance. So this way there are 3 different methods where the conveyance can be obtained. Now the question arises, when we go to the developer or the builder, he is ready to give the conveyance, but what is the procedure to be followed even when the builder is giving a conveyance? So procedure has no other difference. In the case when the builder is facilitating, he will get the landowner and himself and executes the conveyance. But all other requirements need to be followed up. What are the requirements? One, you have to approach the builder. Once you approach the builder, he will also facilitate, or he will appoint his own solicitor, advocate to go through the documents, prepare the documents, or maybe the document that is prepared by the society will be verified. Second, you will have to provide all the documents. It is not necessary that the developer will keep all the documents of the land and building and the members' record. So the developer will naturally ask for the documents of the members where they have paid the stamp duty registration, society registration certificate, and land building, and the various approved plan. Everything will be demanded by the developer. No doubt these are the documents to be kept by the builder, but normally builders say that we don't keep any of the documents. Even if they don't have the documents, they will insist for all the documents. Third and most important is you have to prepare a conveyance deed. The society has to prepare a conveyance deed taking into account all the documents, and then give it to the developer so that the developer will be able to verify those documents through his solicitor and give us the approval. And once the conveyance deed is prepared, next is you have to give it to the stamp duty department to determine what is the stamp duty payable. Normally, if all the flat owners have paid their respective stamp duty on their agreement at the time of conveyance, and if there is no balance FSI, you have to pay the stamp duty of only 100 rupees. And then we have to go to the sub-register where the documents gets registered. So sub-register will call for all the documents against, occupation certificate, approved plans, 712 extract, your conveyance deed, will have again a document called city survey map, property card, and all these documents in order, all will be there, and it gets registered. You have to pay the registration fee of 30,000 rupees. Then you have to obtain a index 2 and certified copy of the conveyance deed, also certified copy of the index 2. Then you have to apply to the city survey office, where the city survey office will call for the information, and then the city survey office will change the name of the old owner to the new owner, that is a housing society who has got the conveyance deed. So this way the 712 extract and the property card will have the new name. So this is how the entire conveyance procedure will be completed. Thereafter we can apply to the BMC, so that municipal corporation, where the property tax are being applied, water charges are being levied, so that also will come in the name of the society. This is how the conveyance can be completed even when the developer is ready to give us the conveyance. Thank you. As I was saying, if the builder does not give the conveyance, the second method to get the conveyance is to go to the court. As I said, we can go to the civil court under section 11, that is called under the Specific Relief Act. Then we can go to the consumer code, because you are a consumer, you have purchased the flat, so you become a consumer. Construction activity is also considered to be services provided under the Consumer Protection Act. Then we go to the criminal code, because section 13 of Maharashtra Ownership Flat Act says that if the developer does not comply with the required obligations as required under the Maharashtra Ownership Flat Act, this will be treated as a criminal offence. So we can go to the city magistrate court also and book the developer. We can get him arrested, and that deterrent factor may facilitate us to compel the builder to go for conveyance. So this way, by going through the 3 different routes, we can get the conveyance. In case you find it is not possible, you don't want to go to the court, and a lot of societies were finding it difficult to go to court and were not aware as to how much time it will take. And even if we get at a lower court the justice, it is also possible that the builder will appeal in the higher court, and once it gets appealed, naturally it takes its own time. So the people were reluctant to go to the court. Therefore, there was a demand from the housing society that there has to be deemed conveyance. So what is this all deemed conveyance about? The deemed conveyance procedure says within 4 months from the date of formation of society, the developer has to give the conveyance. If it does not give, it is deemed to have been conveyed, and that is how the societies whose periods are more than 4 months are over, whose registrations are over more than 4 months, so they can be relaxed and they can think that their society has already got the conveyance under the Maharashtra Ownership Flat Act. What we are trying to do is, under the Maharashtra Ownership Flat Act, the section 11 subsection 3 says that where the societies have not got the conveyance within 4 months, they can go and approach the competent authority, that is none other than District Deputy Registrar, and District Deputy Registrar will hear the parties and grant the conveyance order, as well as he also passes the conveyance order and then executes the conveyance date and gives the conveyance to the societies. This is how the deemed conveyance procedure is being. So deemed conveyance procedure has come into effect on 25th February 2008, where the President of India gave the assent. Thereafter, in the September 2010, rules have been notified, and after the rules have been notified, the District Deputy Registrar, there is a District Deputy every district, and in Mumbai we have 4 District Deputy Registrars, so they have been appointed as a quasi-judicial authority, competent authority, to hear the matters of deemed conveyance and grant the deemed conveyance and also execute the conveyance deed in their favor. So this way, the competent authorities are none other than District Deputy Registrar. We know that the builders can be sent to the jail, but how many of us are interested in sending the builders jail? This amendment is there in the Maharashtra Ownership Flat Act, section 13. Now the question arises, what is deemed conveyance? Is it, many times we say that it could be, a notional conveyance. No, it is not so. It is as good as conveyed, it is treated as conveyed, it is a legal fiction which is created. But what under the deemed conveyance procedure happens is, you are actually getting a conveyance. There is a misapprehension among the number of people, misconception among the people, that under the deemed conveyance you cannot go for what is known as redevelopment, you cannot go for loading the TDR. These are all wrong. When your society is getting a conveyance through the deemed conveyance process, that means you are getting conveyance. What happens is, the law says after 4 months it is deemed to have been conveyed, but when you go to the District Deputy Registrar, he passes an order like a court order, and he also executes the conveyance in place of developer and builder, and that is how you get the conveyance. Therefore, it is actual conveyance. Now the question arises, in order to get the actual conveyance under the deemed conveyance process, what is the procedure involved? The first thing, there is a form number 7 which is given under the Maharashtra Ownership Flat Act, which need to be filled up in a proper, where the developer and the landowner, and if they are not there, their legal heirs are made as a party. Then 2000 is the court fee to be affixed, and all the history of the building and the developer, how he, everything will be mentioned in that application. Then we obtain a certified copy of the land documents. Now when we say land documents, it involves 7 extract, Kami Jasta Patra, city survey map, property card, NA order, all other documents related to the land will be obtained. Similarly, we also will obtain the document related to the building. Now, when we say building, so development plan remark, then approved plan, commencement certificate, intimation of disapproval IOD, and then occupation certificate. With all these documents, we will be submitting to the district deputy registrar. Then we have the individual agreements, stamp duty paid and registration proof, paid receipts proof. Then we have the registration certificate. So even the registration certificate, because ultimately the society is registered, the identity has to be given. Any other document that you rely upon, when you apply for the deemed conveyance, you must have issued a legal notice to the developer, he must have replied, and there may be certain death certificates, or you may have various other documents which the developer must have given. All that can be other documents that you rely upon can be submitted. Similarly, area entitlement certificate. In case, let us assume that in one layout there are 2 or 3 buildings and only one building is going for a deemed conveyance, which is possible. In that case, you have to give the area entitlement certificate. If there is any road width and other cutting has been done and there is certain area which is only left out to the society, even that can be certified by the architect. So you need to give a area entitlement certificate. Sometimes what happens, building is about 30-40 years old, where the survey number is mentioned, the survey number is not mentioned, and right now the suburban area, Mumbai suburban area and various other places, city survey numbers are given where the property cards are made. So in such cases, what we have to do is we have to take a Kami Jasta Patra wherein old survey number will be mentioned and also the new CTS number is mentioned. So with this you can get the what is known as link between both and you can submit Kami Jasta Patra. Then you have to take a search report. What is search report? Search report is nothing but what happens is the advocate appointed by the society need to go through the sub-register office, find out if there are any other transaction which has happened over the last 30 years in related to that city survey number or survey number. If there are any other transaction which has happened or the landowner has sold to somebody else, that need to be brought on record. Now as we say that with all this submission is done, then the scrutiny will take place, and once the scrutiny is taken place, the scrutiny also, if there are any pitfalls or if there are any other defects to be rectified, the concerned district deputy registrar issues a notice for rectification, and once the rectification notice is issued, you can rectify that and get your application amended. Once the application gets amended, thereafter the notice for hearing will happen. As you know, we can always send the builder to the jail, and if we have to send the builder to jail, it does not give you any relief. Similarly, there are many questions which are asked by the people, that housing societies especially, why should we go for a conveyance? Why it is required? No doubt, we know that land will be transferred in the name of society. We know that getting a land is most important. Suppose we don't know, we are staying there, nobody can remove us, what happens? Now I can give you an example of n number of societies, but here I would like to give you Lakshmi Chaya Co-Operative Society. In the case of Lakshmi Chaya Co-Operative Society, which got demolished which got collapsed rather, because of certain mischief done by some of the flat owners and the shop owners. When the pillar got demolished, got diluted and it became weak, what happened is the entire building collapsed. Now, in that society, the society was registered about 20-25 years back. If they had gone for a conveyance, maybe 6 lakhs, 7 lakhs rupees expenses, they would have got the conveyance. But because they thought nothing will happen and they did not go ahead with the conveyance, and later on it was reported in the Times of India and DNA and other newspapers like Hindustan Times that they were required to wait nearly 2 years to get all the documents and to get the conveyance. Unless until conveyance was done, they were not able to do it. All the members of the society, nearly 50 members of the society, they had to wait, stay outside, and everybody contributed per month 25,000 rupees as a rent, which means instead of 6 lakhs, entire society, 50 members contributing, what they did is everybody started losing 6 lakh rupees rent for the period of 2 years, and only after getting conveyance for a waiting of 2 years they could go for redevelopment. Similarly, they also were required to pay nearly 1.5 crore towards the stamp duty, registration, other expenses, which otherwise, if they had collected all the documents, if that was possible to be produced, in that case that was not required to be paid, and before the society could be demolished, if they had provided all the documents, this would have been saved. So this way, if you do not have the conveyance, the possibility is that you will have to spend more money. Now I would be very sorry to say that the Maharashtra government also has levied the additional penalty. Earlier it was 200% penalty if you don't pay the stamp duty. Now it has become 400 rupees stamp duty, 400% stamp duty penalty. So this way various hitches come. Therefore, earlier you do the conveyance, it is better. Now, as I said, there are various documents required. These documents, if the society does not have, you can collect from the various departments. To start with, let us say society registration certificate, which is available with the society. You can go to the society, get it. Suppose you don't have, you apply to the deputy registrar, you get a duplicate registration certificate. Similarly, the individual members have to pay the stamp duty and registration. You can go and collect it from them. If they don't have, you can go to the sub-registrar and get it collected from them where they are registered. If they are not registered and they don't have, in such cases, you will have to pay the stamp duty. Third is agreement with the promoter. Whatever promoter has entered into a development agreement and commencement certificate, IOD, approved plan, all this will be with the developer. Suppose if he does not give, you can go to the BMC. At the time of applying for a BMC, building approval, he need to produce all these documents, which is also available. You may say that these are documents not available. In such cases, you can file an RTI, and if you get a reply that those documents are missing, that is more than enough for you to produce before the DDR that you have taken enough care and enough step to obtain all these documents. Then 712 extract, which is again nothing but a record maintained by the Tahsildar. We call it as Talati. You can just apply with your survey number and you get that. Then Gaon Namuna Che, form number 6, village form number 6, which is also maintained by the Tahsildar's office, Talati office. From there you can get. Similarly, search report, which is given by the advocate, because you will have to appoint an advocate, find out what are the transactions that has happened in the last 25. Then index 2. Now various transactions has happened over a period of last 20 years, 30 years, or there is a conveyance of the old agreement. Then there is an agreement between a flat buyer and the society and the members, or the builder has sold the flat to the individuals. All these various documents which are registered, of that index 2 has to be obtained. Then NA order, property card, and building development agreement, if it is available, all this has to be compiled and submitted to the registrar, and along with the application for deemed conveyance. Now the question arises, against whom the case has to be filed. Many times the societies do come to us and say that our builder, instead of giving a conveyance to us, he has sold to XYZ. So, secondly, people come that the developer is not traceable. Thirdly, the landowner has expired. So we don't know who are the legal heirs. In such case, the promoter definition is very wide. It says that promoter means a person and includes a partnership firm or a body of association of persons, whether registered or not registered, who constructs or who causes construction. Here who causes construction means the landowner. Block or building of flats or apartments for the purpose of selling some or all of them to other persons or to company or a cooperative or association of persons, and includes his assignees. Here the word assignees means it could be legal heirs, it could be the builder who has sold to XYZ, or the landowner has sold to new purchaser because he has purchased because he thinks that he can redevelop the building. So even those assignees are treated as a promoters, and where the person who builds and the person who sells are different, again both of them are treated as a promoter. Here what happens is, in case the builder does not convey, after the period of 4 months, the competent authority steps into the shoes of the builder and landowner, and he gets the authority under the Maharashtra Ownership Flat Act under the deemed conveyance provision to convey the land and building. Now the question arises, now what are the power which the district deputy registrar or the competent authority has? One, he can hear the parties, and second and most important is, after hearing the party, he can execute the conveyance deed in favor of the society, for which you don't have to make a separate application. So this way he gets both the power. He gets this power under section 5A of the Maharashtra Ownership Flat Act, where the district deputy registrar is given the power. Now when we apply for the deemed conveyance, normally what happens is the appearance and non-appearance, which means once we apply, naturally the hearing notice will be issued. The opponents are issued a legal notice by the competent authority to come with the various say or whatever the objection, suggestion they want to say. So they will be invited for the hearing. After the hearing is done, the appropriate order will be passed. It is also possible that during the hearing, the other party may say that we need to verify the documents. They may ask us to produce the documents. They would like to inspect the document. In such case, the applicant need to produce all the original document, whatever document he is relying upon. And then the parties are asked to give their replies in writing. So the respondent, that is a builder or the landowner or their legal heirs, give their say in writing, and thereafter they also gets the chance to reply on that. So this way the applicants on that, there is a respondent's reply, then again the applicant's argument or reply, and this way then there will be a written argument. So this way various exchange of views takes place between the parties in writing in the presence of the district deputy registrar. Opponents may file the written say. They can also make a oral arguments, and the most important is there is no cross examination. Unlike in the court, what happens is there is always a cross examination takes place, and then witness examining the witness, cross examining the witness, and leading the evidence. This is where it takes time. Here what happens is the evidence is led even before the application is accepted. Once the application is accepted, that means all the required proof has been submitted to the district deputy registrar, and thereafter what happens is, if there is any additional say that the respondent wants to put in or counter, only that will be taken in writing, and thereafter the competent authority takes the view. Within 6 months from the date of making an application, the competent authority need to decide on the matter. They need to hear, close the file, and also pass the order. So this is the beauty. So where there is a time limit is laid down on the competent authority. Once the order has to be passed, once the hearing is over, file is closed, then the order is passed. This order need to be given in speaking. When I say speaking order, means if the order has to be given in favor of the society also, they have to say why he is inclined to give the order in favor of the society. If the order has to be rejected, that conveyance order has not to be given, deemed conveyance need not to be given. In that case also, the strong objection which is taken by the opponent need to be emphasized, and he need to agree on, that competent authority need to agree on the views expressed by the opponent, and thereafter only he can reject. Without a proper reason, neither the conveyance can be granted nor it can be refused. So this way the applicant case is decided within 6 months from the date of giving the application. Now once the deemed conveyance order is issued, the competent authority advises through the order that the applicant has to prepare the deemed conveyance deed. So he prepares the deemed conveyance deed, and once the deemed conveyance deed is prepared, it will be sent to the adjudication department, collector of stamps, to determine what is the stamp duty payable. Because if everybody has paid the stamp duty and there is no problem, in that case only 100 rupees is payable. If out of, let us say, 100 flats, 98 people have paid the stamp duty, 2 people's stamp duty is not paid, in that case at the time of deemed conveyance deed, that collector of stamps will demand that 2 people's stamp duty should be paid by the society, and then demand notice will be issued. Once the payment is made, that deemed conveyance deed will be certified saying that the appropriate stamp duty has been paid, and this certification will be done by the collector. And once the certification is done, we have to go to the sub-register office where the agreements are registered, where in such cases the district deputy registrar executes the conveyance deed by stepping into the shoes of the landowner and the builder against whom the deemed conveyance order has been passed. And then he also gives a letter saying that he, being a gazetted officer under section 88 of the Registration Act, he has been exempted from appearance, so that he need not, the district deputy registrar need not come before the sub registrar. So this way, only by appearance of the society being one party, so the entire conveyance deed gets registered and index 2 can be obtained. So this is an example of a deemed conveyance deed where the competent authority, in place of the developer, that is Sunshine Enterprises, the competent authority has executed the conveyance deed. So you can see that at the time of vendor, the name of district deputy registrar is written, competent authority is written, who executes the conveyance deed as a vendor on behalf of the seller. Same way, the society being the purchaser, society has put its seal and also signed the conveyance deed. Why this deemed conveyance is so complicated? No doubt, as we know, that conveyance means one person sells, another person buys, and there is a signature of the seller and the buyer, and the society need to get it. If it is not received, the district deputy registrar will step into the shoes of the builder and the landowner. He hears the parties and he executes the conveyance deed. You pay the appropriate stamp duty and get it registered, get the index 2, get the property card changed. This is very simple, but this also has various legal implications, and there are various provisions of the law applicable. It is not the only one act, Maharashtra Ownership Flat Act, which is coming into effect. We starts with Transfer of Property Act, then we have Registration Act, we have Bombay Stamp Act, we have Maharashtra Cooperative Societies Act, we have Income Tax Act, then Maharashtra Ownership Flat Act. So these are the various acts which are affecting. In addition to that, there are various cases where the ULC, Urban Land Ceiling Act, is applicable, then the Criminal Procedure Code, and then the Civil Procedure Code, and then we have what is known as Development Control Rules. In order to develop the building, there is a development control rule, whether there is a balance FSI, not balance FSI, what is the road cutting which has gone, all that need to be seen. Land Revenue Code. So when the property card gets changed from one hand to another hand, and you have to verify what was the original area, is there any area taken over by the government. So Land Revenue Code, bylaws of the society. So this way, various provisions of the law is applicable. Second, there are various departments that need to be visited. An office bearer or any person, even sometimes an advocate, may be practicing only in civil code. He may be practicing in city civil code. He may be practicing in criminal code. He may be practicing in cooperative code. So even the advocates have limited resources to do all this. So in order to have the holistic view, and in order to see that somebody who is experienced in this line and who does all this, you need to look into that person, so that you will be able to give a very good package deal to them. And various departments need to be visited, and you need to have the all the experience of those departments, to start with city survey office, to collect the property card, either old, latest, and thereafter once the conveyance is done, to get it changed in the name of the new society. Similarly, collector of stamps, in order to determine the stamp duty payable, if there are any balance available that need to be paid. Similarly, sub-registrar for registration, then assessment department for getting the various plan, maybe approved plan, then find out the various tenements in the absence of the plan, then NA order from the collector of stamps, collector office, that is a NA order is being issued by the Tahsildar and collector, then revenue department, ULC order, and many more departments, depending on if it is a charity commissioner's case, then you will have to go to the charity commissioner. So this way various issues also arise. Now let us analyze some of the judgments of the High Court wherein the conveyance has been granted. The first is, there are various misapprehension that without OC or without completion certificate, deemed conveyance cannot be granted. In one of the cases of the society where Hsg Soci developers went to the Bombay High Court saying that against him a deemed conveyance has been given by the competent authority, saying that OC is not there or completion certificate is not given. The High Court, Bombay High Court held that completion certificate is not a requirement, and even if it is a requirement, it has to be given by the developer and his own misdoing cannot be a reason for not giving the conveyance. In one of the matters, what happened is Devnar Avanti Co-Operative Society, they had applied for the consumer court. The matter also was referred to the competent authority, and thereafter competent authority took the application, hearing took place, but the application, after the hearing is done, the competent authority kept it pending, saying that unless until you withdraw the case at the consumer court, he will not be able to pass the appropriate order. Matter was referred to the Bombay High Court, and the Bombay High Court held that once the matter is before the competent authority, even if the matter is pending in the consumer court, the competent authority should not be, stopping from giving the order. So the Bombay High Court directed that the order has to be given. In which case, and which means that even if the matters are pending in other courts, you can still go for the deemed conveyance, because it is a quasi-judicial authority. He steps into the shoes of the builder and landowner, and if the landowner and builders on whose behalf he is giving a conveyance is granted, that means it is very simple matter. The matter is like this, that he is supposed to give the conveyance, which if he has given, the matter which are pending in the other court become infectious, and therefore that can be withdrawn, and that will not have any stand in the court of law. In one of the matter where Bipin Construction Company and others went against the deemed conveyance order, saying that there is a balance FSI. The Bombay High Court held that even if there is a balance FSI, because the building is considered about 20-30 years old, and the builder was not able to use, and that has got vested with the society, therefore even if there is a balance FSI, the conveyance can be granted, and that all balance FSI will get vested with the society, and the deemed conveyance which was given was upheld. Similarly, there is another matter where Suleiman Abdul Razak Nisandar as a petitioner went before the Bombay High Court, saying that there is a dispute about the open space between the two buildings, and the dispute is also about the FSI to be used. In such case, the deemed conveyance which has been granted should be set aside. The Bombay High Court held that even if there is a dispute, the building is registered, they have got the right to get the conveyance, and the conveyance has been properly given. So open space dispute or the balance FSI cannot be the reason to withhold the deemed conveyance. There are n number of judgments which have even gone up to the Supreme Court, which has held that deemed conveyance is a proper method, and where the builders are not giving conveyance, the district deputy steps into the shoes of the builder and the landowner and grants the conveyance. And in order to get the conveyance, I am strongly recommending you that you should go for deemed conveyance. Let me tell you, as a Maharashtra Society Welfare, we have engaged n number of advocates who are specialized into this. We have a legal team, we have a consultant, panel consultants who will study your case. If required, those people will come to your society and explain the matters. They will issue the legal notice to the developer and landowner, and to tell you from the beginning, that means from the day of consulting you, meeting your members, passing the minutes, appointment letter, giving a legal notice, and then presenting before the DDR and getting all the relevant documents, and then till the property card is transferred in the name of the society. All this gamut of work is undertaken by these panel advocates and the consultant, and as an association we always keep an eye on them, and we can assure you that there will not be any cheating that can happen, or whatever assignment that you will be given definitely will be discharged by this type of consultants. So we also can monitor, control, and see that the societies who go through the association also get the justice. Thank you for watching this video, and I hope it will be a definitely eye opener for you, and you will proceed with the process of getting the deemed conveyance. Thank you.